Hello everyone. Today's lecture will be based upon the patent laws with respect to what are the rights of patent holder. We will go through exactly what do you understand by exclusive rights when we say that a patent holder gets exclusive rights for a period of 20 years from the date of his application. Once he has been granted patent, what all things he can do to commercially exploit the patent which he has received to make sure that he's getting maximum returns or rewards to his invention. We will also go ahead to understand what are the limitations and exceptions to the rights of patentee and a concept of compulsory licensing, which is one of the concepts which has been critically acclaimed throughout the world. The next part of our session will be based upon understanding licensing and assignment of patent to know as to what are the different ways in which a patent holder can go ahead and commercially exploit his patent. We will understand the difference between licensing and assignment, what are the rights which are transferred to other party in case of assignment and in case of licensing. So let us begin our today's session with the rights of patent holder. In our last session, we had gone through four important criterias for an invention to become patentable in India. We said that it must belong to the patentable subject matter. That means it should not be excluded from section 3 and section 4. We said it must be novel or new invention. Likewise, it should have an inventive step and it should be non-obvious. And the last one was that it should be capable of industrial application. Once an application is filed with the controller of patents, the controller of patent goes through the application, understands the specification, understands what exactly is the invention, does the prior art search, which we already talked about last time. And if the controller is convinced that the invention has been provided with respect to all the formalities which are provided under the Patent Act, likewise it is new, it is invention, it involves industrial application as well as it involves inventive step, and if the controller is convinced that all the specifications, the drawings, the layouts, everything has been provided by the applicant as per the Patent Act, then if all the criteria are met with, the controller goes on granting the patent. The term of the protection of patent is 20 years from the date of application, which we have already said. Once the patent holder receives the certificate, that means receives the patent, he gets certain rights which are considered to be exclusive rights under the Patent Act 1970. The first right is right to exploit the patent. The word exploit here should be taken in a positive sense. The word exploit here typically means that to go ahead and explore the usage and commercial viability of the patent which has been received. So the patentee or the patent holder, as it is commonly known as, gets exclusive rights. The word exclusive again means that the person gets rights, exclusive rights, to exclude everybody else from doing the activities or doing the acts which the patentee has been given a right to do. That means to exclude others from making, using, or importing or selling in India the product which has been received the patent for. Likewise, if the patent has been granted to the process, the exclusive right is there with respect to using the procedure or using the method in the territory of India. If you remember, we had said last time that the patent rights are territorial rights. That means you can utilize the rights only in the territory of India. If you have to go and do it outside the territory of India, then in that case you require special patent rights outside the country, in the country where you want to exploit your patent. For example, let's say if I have invented a machine which is going to help separate egg yolk with egg white. Let's say it is an invention, nobody has done it, and the payer, registrar, or the controller of patent has granted me the patent for that. I get a right to not only use it for my benefit, use it for, let's say I run a poultry, not only use it for my poultry, but to go on manufacturing the same machine n number of times. Likewise, whatever material, raw material is used to manufacture that machine, I get a right to import it, or I get a right to sell that machine in India at whatever cost I want, whatever terms and conditions which are legal, obviously I want, and as well as go on licensing it, assigning it, and selling it in India, marketing it in India. So as a patent holder, I get exclusive rights to go on performing all the legal activities which are permissible as well as profitable to commercially exploit my patent. Likewise, if the patent is granted for the process, I can use that methodology, I can use that procedure in India and go on using that procedure or process to manufacture certain materials. The second right is right to grant license. This is one right which we will discuss in further slides more. Right to grant license as well as right to assignment is another right which the patent holder has, the sole right which is granted. Right to license and grant assign license or assignment typically means that when I am as an exclusive right holder get certain rights, it may not be possible for me to exploit it personally. So what I do is that I transfer certain of these rights to another person and permit that person to go on using that invention. For example, taking the machine example of separating egg yolk and egg white, if let's say I have my plant located in Mumbai and I want to start manufacturing that product in Delhi. Now it may not be possible for me to personally every time visit Delhi and start the manufacturing unit and go into it. So what I do is that I appoint a local person from Delhi who, let's say, is my friend, and that friend is also into the poultry business. So what I do is that I license the right of manufacturing that product and manufacturing that invention in Delhi up to certain units, by way of which he has to give me certain royalty. Royalty means the money consideration, because the person is using my invention, is using my certain rights. So when I'm transferring my certain rights, I'm licensing my rights. That is also a exclusive right which is obtained by the patent holder. The third right is there, which is the right to sue for infringement. Now the word right to sue means right to file an official complaint. In layman's term, we say that the person has filed a case, a court case. Infringement is something which we will be studying in our next sessions, but as of now, just remember, infringement means to do something which you are not legally permitted to do. Like for example, the right to sell the invention is only in the hands of patent holder. If I start selling the invention for which I don't have any patented rights, then I am infringing the patent law, whereby I am taking away the exclusive rights of the patent holder, which I am not legally permitted to do. That is the meaning of infringement. The patentee has a right to file a case for infringement of patent. There are various agencies which are set up. First application can be given to the controller. You have IPAB. That is something which we will be studying in our further sessions as well. Now once the exclusive rights which are granted to patent holder, if somebody goes on infringing it, the patent holder suffers certain losses, certain damages, because it is his exclusive right for 20 years. And in order to recover the damages or the losses or the infringement related cost, the person can go and file a case in the appropriate authority. The next right, which is the right of patent holder, is right to surrender. The word surrender means to give back. The controller grants the patent for a period of 20 years. However, under certain circumstances, the patent holder may want to surrender his rights to patent, in which case a notice must be given to the controller in a prescribed manner. Likewise, the advertisement of such a surrender notice will be published in the patent journal. Patent journal is like an authoritative official document which is published by the controller under the patent law, which goes on including all the information and all the official records which are to be published as per the procedures given under the patent law. Once the publication is done, an opportunity must be given to the people, to the citizens of India, to oppose the offer of surrender of patentee. If somebody feels that this surrender, once it is done by the patent holder, the invention will come into public domain and it may not be beneficial for the society, then there might be an opposition which might be done. The next right is right to use and enjoy the patent. This is one of the most important rights because a person puts in lot of efforts, time and money to create or to invent certain product or a process, and he should get full right to use and enjoy that product. Likewise, right to exercise or to make, utilize or convey or offer any patented substance or article in India, or to practice or utilize, or the process or technique associated with that invention is something which the patent holder gets. They can be exercised either by the patentee or by the licensee or by the assignee, like we have already discussed. So these are couple of rights which are granted under the Patent Act. Obviously, when you have a right, there are certain exceptions to the rights just to make sure that the integrity is maintained in the society and the patent holder does not utilize the rights to exploit people or to exploit his invention in a negative sense. The limitations and exceptions to the rights of patentee are as follows. First, if that patent has been used for any research or any experimental utilization. Meaning what? That if there is an invention which has been patented, but that patented invention has been used by somebody else apart from the patent holder for certain research or for some experimental utilization with the permission of the patent holder, then that is something which the patent holder has to let go. Understand, when you talk about certain inventions or certain other IPRs as well, like we said, a balance has to be struck between the rights of the person who has created or invented that IP, intellectual property, and the rights of the society. Development of the society is necessary, for which research is necessary. So if the published patent, if the process or something is utilized with the permission of the patent holder, then it will not be considered to be infringement. Likewise, usage on outdoor vessels, that means, like we said, outside India, if the patent is used and it is made and it is accepted, that is something which is not permitted. The territorial rights are restricted only to the country of India, and the patent holder does not have any right to exercise his exclusive rights outside India. Likewise, the patent holder, in case receives any administrative authorization from any professional with respect to usage of that patent, it will have to be granted. For example, compulsory licensing is one such acquisition by the government of your invention. Likewise, reduction of patent rights and similar imports is a limitation or an exception to the rights of patentee. Compulsory licensing is one such way in which the exclusive rights of the patent holder are curbed in a certain manner. Curbed in the sense limited. Now, this is something which the government of India has got authority to do. Upon an application which is received by the controller of patent within after the expiration of 3 years from the date on which the patent was granted, the compulsory license can be obtained. However, there are certain conditions for that, in which case the government of India, if satisfies or the government satisfies the following conditions, the government will get certain rights over the patented invention, which is the reasonable requirements of public with respect to the patented invention have not been satisfied. Reasonable requirements of public meaning, let's say there is an invention with respect to medicine for coronavirus, and there is a patent which is granted to one of the pharmaceutical company for the pandemic which is currently going on throughout the world. Now, if that pharmaceutical company, after receiving the patent for the vaccination against coronavirus, does not start manufacturing it or making it available to the public, the government has got a right for obtaining compulsory license, because, like we said, the balance between the society and the patent holder must be maintained. if certain drugs are life saving, or if certain products are life saving, and if the patent holder is not providing access to such life saving products or drugs for the public, then in that case the government can obtain the compulsory license. Another condition is that the patented invention is not available to the public at a reasonable price. Let's say, taking ahead the same example, if the vaccination for coronavirus, let's say there's an injection for it, and every injection is costing 10,000 rupees. Now, that is something which is not a price which is affordable to each and every citizen or each and every person. If let's say a person has got 10 family members, 10 into 10,000 is something which may not be affordable for everybody. So if the patent holder is not providing the providing invention to public at a reasonable price, the compulsory license can be obtained by the government for providing the patented invention. Likewise, the patented invention is not worked in the territory of India, like we said, it being the territorial right. If in India the patent holder is not providing the invention to the public or for its industrial application, then in that case compulsory license can be obtained. Understand, the word which we are using here is not assignment, the word which we are using here is license, simply meaning that the ownership of that invention will still remain with the patent holder, but it is just certain rights, maybe with respect to use, or maybe with respect to selling, or maybe with respect to manufacturing or marketing, which will be obtained by the government for the benefit of the society. But even after getting the compulsory license, the ownership of that invention is still retained by the patent holder, and the government only gets a right to use that invention for certain particular usage or for certain utility. And this is something which is one of the biggest exception to the right of the patent holder. Now in our next session we will go ahead with licensing and assignment of patent. Thank you so much.